Judge Sabaugh, our circuit court judge, and thanks for being on the show today, but I got to tell you, as a prosecutor and a circuit court judge, we got to know who you are. So why don't you give us a little background about where you came from, what's going on in the world of judging?
First of all, Mr. Lucido, thank you for being here and welcome to the courtroom, my courtroom here in the 16th Circuit Court. I'm one of 11 judges in the circuit court that handle a criminal civil docket. So all the criminal cases are going to come up to the circuit court. All the felony cases are going to come up to the circuit court to one of those judges, randomly assigned. My background, it's been really an honor and a privilege for me to be in the justice system beginning as a prosecutor when I first became a lawyer 25 years ago.
Hey, you're getting
now,
old.
I worked in the prosecutor's office for about 8 years, a line prosecutor like all that you have under your power there, handling cases in the district court and the circuit court. And then I was appointed to the district court bench, 37th District Court in 2008, and I worked in that court for 14 years. And then I was appointed here to the circuit court.
So that the viewers and the audience know, 37th District Court is the Warren District Court.
I think still the busiest
court in the county.
Busiest in the county, I think third in the state.
Yeah.
And a large volume of cases. You know, I've always heard that it takes 10,000 hours to be an expert. I think I've got my 10,000 hours in, and moving up to the circuit court has been really for me a natural progression and a challenge that I was looking for. And my job is to serve the public. This courtroom, every courtroom is the public's courtroom, and I never forget that. And what I hope to do here in your program, I think is great, is to educate the public on the law.
That's what it is. So you were in the district court. We had a judge from the 39th District Court, Judge Bodecker, and he gave everything that happens in the criminal arena. I know what you said to the viewers. You handle not just the criminal, but the civil dockets, which are, you know, car accident cases, two people suing each other under breach of contract.
Civil cases would be generally anything over $25,000. Any complaint filed with damages over $25,000.
Come to the circuit court.
Yes.
And if they're less than 25, it goes to the district court.
Correct.
Perfect. Let's focus today on criminal, because my office, your former office, when you were a prosecutor, doesn't do civil except for the forfeiture cases. And we do very few of that today. So let's get into this. After a case has had a preliminary exam in the district court, or it has been bound over, it comes up to the circuit court for felony cases.
Correct.
Tell us about that.
Okay. So the first step, once there's a bind over out of the district court, and that could be after a preliminary examination, after a hearing, where the judge has to determine, it's not a jury there for a felony bind over. The judge determines whether, by probable cause standard, whether a crime was committed and the defendant committed it. Only by probable cause standard, not proof beyond a reasonable doubt.
And those are on felonies because the district court does have jurisdiction to have a jury trial or a bench trial for misdemeanors.
Yes, misdemeanors would stay down there. Now, if you have a case where there's a felony and a misdemeanor and it's bound up to the circuit court, all the charges would follow.
Perfect.
So
when it gets up to the circuit court, what's the first hearing or the first event that happens?
It's called the arraignment and conference.
Also
the
known
arraignment
as the
conference.
AOI?
Yes.
Arraignment on the information?
So, and again, there's so much of the process that is to advise the defendant, the accused, of their rights. They are innocent unless proven guilty beyond a reasonable doubt. Foundation of our justice system. So they, again, when they arrive at the district court for the arraignment, because some of the charges may change. You may have some of the charges dismissed by the district court judge.
Correct.
You may have charges added at the preliminary examination. So that comes up on an information. And then they're provided that information. They're advised of the charges, the maximum penalty, and their rights. And their attorney is there always. If they are unable to afford an attorney, there's a court-appointed attorney. Right. And there's also a conference. A lot of what happens, everything on the record is in the courtroom, but the parties are free to conference together in the conference room that we have. So a lot of the conferences that occur, that's where a lot of your plea negotiations occur, and that's what we're going to talk about, I'm sure, today as well.
We're going to talk about the fact that the case actually is really getting into now, after a preliminary exam in the district court, and or the defendant has a right to waive the preliminary exam and stand mute and be bound over to the circuit court for
Correct.
the next conference, which is the arraignment on the information, rereading charges, or if they held an exam, any charges that were dismissed, and or whether or not any charges that were modified, reduced. That is what the bind over is to come up to circuit court.
One way I like to think about that, because people, in the federal system, you have the grand jury process. Michigan, we have it, but we don't use it. We use the preliminary examination stage where the judge determines whether probable cause occurred. Now, there's also, the circuit court also will hear an appeal on the bind over. So that may be challenged the bind over may be challenged. It's called a motion to quash the information.
So a defendant or the accused has every right to go ahead and challenge what the district court did by way of submitting maybe the transcript as well as a motion to quash that bind over and say, hey, that bind over was wrong. There was no probable cause that could have been found, and argue the merits of what the judge found.
Yes, we have, this is where the majority of evidentiary issues are dealt with here in the trial court on felonies. Now, there may be challenges to evidentiary issues in the district court.
Yes.
But, I was in the district court for, I said, about 14 years. You didn't see them very often. It was more reserving that right to challenge it. So you've got search and seizure issues where the defense attorney may be challenging that it was an unlawful search or an unlawful seizure, or they may be trying to keep statements out.
Which are all preliminary issues before a trial, meaning
absolutely.
You try to flesh out all of those things that a defense lawyer could bring a motion for to get to the hallmark of what the essence is of the actual charges that are going to be heard by the jury or a judge.
Everything is aiming towards a fair trial. That's the goal. Now, not all cases go to trial, as we'll talk about.
We're going to talk about that.
Everything is aiming towards a fair trial. So if something needs to be excluded, if some testimony needs to be stricken, oftentimes I'll rule on that before the trial, because there's a lot that the jury can't see.
The jury has an opportunity not to see all the pretrial motions and all of the evidentiary hearings that take place, but they're going to hear, after the rulings have been made by yourself, or it may be a district court judge, what is left of the case.
Correct.
Okay. Let's get into the pretrial proceedings. There's pretrials that are held.
Yes.
What do those pretrials do in a case that's already been bound over and or waived upstairs to the circuit court?
So again, a lot of what occurs at a pretrial occurs outside of the court's presence. So there'll be pretrial conferences going on in our conference rooms with the attorneys, prosecuting attorney, one of your assistant prosecutors, and the defense attorneys. You're going to have at that point consultation with victims, with probably your detectives. We call those the officers in charge. The defense attorney is going to be consulting with their client. They're really going to be kind of flushing out the cases, and they can share information with each other, which they may not necessarily share with the court if there's something that, a lot of these cases resolve by way of plea bargain. There's nothing wrong with that.
So, there's nothing wrong with it. We have roughly anywhere from 19,000 to 22,000 cases here in Macomb County a year. That's an awful, this is criminal cases.
My number is,
what are you at?
I think we've got 3,000 criminal cases, felony cases in the year 2025.
So let me ask this question. The main share of them dispose in the district court, apparently, because we open up every file. We can tell you how many district court files we've opened, because we do handle district court, as you remember, which means misdemeanors that are occurring in a jurisdiction such as the sheriff's department are coming through our prosecutor's office, and we're prosecuting these as we are prosecuting felonies. But let's talk about why there is so many that are resolved by a plea?
Okay.
Because you got the best of both worlds. The viewers are listening to a judge, 14 years in the district court, knows all the nuances of every single proceeding. Former prosecutor for 8 years.
Yeah, almost 8 years. Yeah.
And now a circuit court judge presiding over cases that come from the district court. Why so many that plea out?
Well, the first thing is the reality of if all of these thousands of cases were to go to a jury trial, the court would be overloaded. I mean, we'd have to have 100 judges. We'd be running 24/7. That is a reality. Okay.
It's cost prohibitive,
but everyone has an absolute right to a trial by jury. And so if everyone demanded a jury trial, we would have to accommodate that.
That's right.
So why have a plea bargain? Well, because each case is different. You have aggravating circumstances, which means in some cases the defendant should be penalized more if they're convicted or if they plead guilty. You may have mitigating circumstances. And that's really one of the key factors of a prosecuting attorney, and especially the elected prosecuting attorney, is you are setting a course for how you want to handle cases, and really all of your assistants are following that course. So you may have a policy where you're going harder on certain crimes. I know you've developed some policies towards that.
Plead alluding. It was our discussions, Judge, that made me realize, wait a second, they're putting everybody's life in jeopardy and innocent parties on the road. There's no excuse not to obey a lawful command of a police officer that puts their bubbles on and their sirens. And I appreciate
there's also mitigating circumstances, youthful offenders. You may have someone that has a serious drug or alcohol problem, has a mental health condition. These are mitigating circumstances. When I get the full report, the pre-sentence report, which we'll talk about, all these factor in a plea bargain. Does somebody have a lengthy criminal history? Does someone not have a lengthy criminal history? Are they a first-time offender? What does the victim say? What does the detective sergeant say? So they really conference on these, and sometimes I'm involved in those conferences when they want me to get involved, and that's usually when there's some type of sentence agreement.
It's also this: if there is victimless crimes, which means somebody is drunk driving out there or somebody's using drugs out there.
I disagree with the misnomer.
Well,
there's no victimless crime. There may not be a named victim, but every crime has a cost to society.
I agree with that. But when we call it somebody that was not injured or somebody that was not was scammed, let's say, when we have an individual that drunk driving, somebody using drugs, somebody who does something that is not to a third party but to themselves, let's say, and they're arrested, they may want to resolve their case by way of a disposition quickly.
No, I agree. I think that, again, no one is being forced into a plea agreement. It has to be their own choice. When I take a plea in this court, they're taking an oath, they're advised of all the rights. I make sure no one threatened you, no one coerced you. All of that has to be done on the record.
Yes.
And I think I believe the reason for it is, if someone does choose to plead guilty, they are making a big step towards taking accountability for their actions.
Good way to look at it.
That's a big step for someone to do. If they choose to plead guilty.
Or maybe the evidence is so overwhelming. Yeah. What are they really trying today with body cams that have become mandates to police officers and police agencies? The movie is in progress before a jury to show all of that evidence that's been taken from the streets to show proof beyond a reasonable doubt what has occurred in the video or the body cam.
Yeah, I mean, in 25 years, Peter, the technology that has advanced has really changed so much with the evidence that we see in the courtrooms, with the discovery that your office is able to provide so quickly, the electronic discovery. I believe it's helped the process.
But it's taken us longer to look at all these videos. Yeah. If there's 16 cops at the scene, that everybody's got a body cam, I have the assistant prosecutors have to review each and every one of those body cams for every detail to make sure that we can prove our case before we sign a warrant.
But what I also wanted to say, you know, in all those years, when I was a prosecutor, there was no public defender's office.
No.
Now we have a fully funded public defender's office. We have excellent attorneys in that office as well, as you do in your office. And so I think we really have a fairer.
Yeah, fairer. I don't think the resources
they have
were
more
there
resources.
Years ago, when a Polaroid camera was taken from a police department, they put it on a Xerox machine. I know it's dating me, and that was given me as part of the evidence package or a written statement. Today, everything's done with electronics, and you're right, the data is quick and swift, but it also is a time constraint on the defense and on the prosecution to review all that so that there is fundamental fairness throughout the proceedings.
Yes, that's key.
Now, after a plea's been taken, or let's go into a jury trial, everybody has a right to a trial by a jury.
Yes.
And that process is picking jurors and making sure that, you know, the process is still being played out, but the fate of the individual who's accused is going to be decided by a jury of their peers here in Macomb County. Yeah.
Well, you know what? I want to take this opportunity because jury duty is so crucial to our democracy and participation in our democracy. Everyone has the right to vote, but they don't have to vote, right? We don't have a draft. But jury duty is your obligation. This is part of the social compact. That when you're called to jury duty, and I know a lot of people dread when they get the notice for jury duty. And we call in, we fill our courtroom with potential jurors, and oftentimes everyone's trying to avoid it. And what I try to express is that this is so fundamental to our democracy. This is a big deal, that we have trials by a jury of one's own peers. And when we have jurors that are not showing up or that want to get off the jury, how is this going to run?
It's not going to run. And like democracy, we can talk about it all day long, but the reality is your citizenship here in this country, being a citizen of the state, being an individual that says, I have a duty and responsibility to make sure that fundamental fairness is tried in each and every case. If only 40% are actually coming to the calling, we do have a problem in this county and the state, because it's just not this county. It's other counties I'm hearing, and they do everything to try to get out of it. But the reality is, you want a selection of individuals that are going to be like you, your peer, in a community in which the law has to be enforced.
That's the voir dire process is an opportunity. So we call it, in the law we use a lot of Latin. It means to speak the truth, the voir dire. I think it's Latin. So what happens is we have a few demographic details of each juror. Basically, when you get called for jury duty, your name's being pulled from the driver's license data from the Secretary of State. Randomly, you're picked out. So myself as the judge, I know each judge does it differently, but I begin with just asking some foundational questions of each juror, their background. We do get into private details. I always tell them if I'm asking you something
personal
that you don't want to disclose in front of everyone, we can do that. We can have everyone out of the courtroom and discuss that privately. Let me tell you why, Peter, okay? You might have a case of someone accused of criminal sexual conduct, a criminal case, right? And you may have a juror, a potential juror, that has been the victim of you would not believe how many times that has happened. And, you know, if someone has that trauma from being the victim of a sexual assault from their childhood,
they may be biased.
There's no way that you can ask them, even if they feel they can be unbiased, to put someone through that. It's hard enough for the average person.
I think what you're doing is put them in a predicament of like, you know what? I know more than what everyone else does. I've been a victim to the circumstances.
But my goal, the goal of the defense attorney, the goal of the prosecutor is to choose a fair and impartial juror.
Good.
That's the goal. So they're going to be asking questions. They'll talk a little bit about some legal issues, but I don't let them get too much. They can't get into the case, but they're trying to determine, can this juror be
Fair and impartial. There you go.
You know,
So we have jury questionnaires that they fill out. Those are reviewed by the defense counsel as well as the prosecutor.
Yeah.
They have a chance to, if you let them voir dire, like you said, ask the jury questions after you give them what's called basic preliminary questions about whether or not they want them to sit on their jury. And then there's preemptory challenges and challenges for cause. Talk about real quickly, because we got a lot to cover, peremptory challenge versus a challenge for cause.
All right. A peremptory challenge is essentially if each party has the right to excuse a limited number of jurors.
Correct.
Again, the fair playing field. For any reason other than can't discriminate based on race or any reason such as that, right? But it could be any reason.
Meaning you have a right to look at somebody and said, I'd like to thank juror number 12 for their services, and I'm excusing juror number 12.
Don't have to give a reason.
That's
but
right.
It could be challenged if the opposing side feels that that person was challenged because of their race, then there's a process for that as well, where that could be challenged. But what you're going to, when you talk to probably every one of your assistants, they're going to have a different theory on who makes a good jurors. You know, some attorneys say, you know, I never want a teacher on the jury. I never want an engineer on the jury.
They're too technical. Our accountants, they're too precise.
But what I always say, everyone, as long as they can be fair and impartial, what makes a jury to me so amazing is that you have 12 jurors. We put 14 on because we have 2 alternates.
Alternates, right.
All different walks of life from across this county, Peter. Engineers, doctors, you may have a lawyer.
Right, and police officers.
You're going to have a lot of working people that are really working in restaurants, working in factories. So you have this broad spectrum, and they all have to go.
How many are in the pool? How many are in the pool downstairs on the first floor that are called up? Not all of them, but enough to fill the courtroom. How many are in that pool? Like 150, 200 on a given jury day in Macomb County?
Yeah, it varies.
That's a lot of people coming down to Mount Clemens.
But here's the amazing thing. Every time I have a jury trial, it amazes me that we take these people from all across our county, all citizens that showed up to serve their duty, and they all have to agree. They all have to agree. In a criminal case, it has to be unanimous. Yes. Not so in a civil case.
Well, if one holdout sits there, everybody keeps working towards getting the facts, getting the evidence, looking.
Isn't it amazing? If you could put Congress in a room and get them to agree, do you think
we would have a better society right away? So at the conclusion, the jury would deliver its verdict, or if it's a bench trial, you are the trier of the facts and the evidence and looking over everything. And at the end of the day, a verdict is delivered one way or the other by yourself or by a jury.
Yeah, I do want to talk about that. Is once the jury is selected, the trial begins. The trial would begin with the opening statements. The prosecution bears the burden of proof.
Which means they have to prove all the elements of the crime.
They have to prove beyond a reasonable doubt every element of the crime. The defense has the right to give an opening statement. They don't have to give an opening statement, or they can reserve it for after the prosecutor's proof. And then the witnesses are called, and each side has the right to question the witnesses. And then after both sides have called all their witnesses, there's closing arguments. And then I provide the instructions to the jury. What my job is in a trial is to rule on the law. Okay, I want to rule on the law to make sure there's a fair trial.
And
if there's an objection,
important. You're like the referee.
Yeah.
Making sure that the fairness in the case itself is being played out, because the defense has a right to go ahead and make objections or challenge evidence.
Correct.
And the prosecution weighs the entire burden to prove their case. They brought the case against the individual.
Correct.
At the conclusion, and there is let's say that they're found innocent by yourself or jury of their peers, what is the process after that?
Guilty or not guilty.
That's right.
I mean, it's presumption of innocence, but they have the defendant must be proven guilty, or they are acquitted or found not guilty.
Prosecution bears the burden regardless.
Yeah. What happens if there's an acquittal?
Yes.
So if there's an acquittal, the charge is dismissed. They cannot be retried, right? You can only be tried once for that crime. At that point, normally what happens is if there's a bond, we haven't talked about bonds yet, but if there's a bond, perhaps the defendant may be held in custody until the outcome of the trial. That bond would be returned and they would be released.
Go on if they're found guilty.
If they're found guilty, there is a process for that as well. There's a pre-sentence interview that has to be completed, so they have to be scheduled for sentencing, and that's the court's job to sentence the defendant in a criminal case. Again, once they're found guilty, if there's a trial, or if they choose to plead guilty by way of a plea bargain, or if they just choose to plead guilty, I can't just sentence them from the bench on a felony. Now, in the district court, you can generally do that because they're misdemeanor cases. On all felony cases, we need what we call a pre-sentence investigative report. This is your old job when you were a probation officer.
Correct.
This is such a resource for the courts and the attorneys because the probation agent will interview the defendant, and the defendant would have the right to have their attorney present as well. And they would essentially gather all the information about the case, all the information about the defendant, because in Michigan, my job as the sentencing judge is to consider the offense and the offender. It's called individualized sentencing. So not everyone, and some people may think this is not fair, that not everyone is given the same sentence because the variables are different. And that's what we're talking about when we talk about sentencing guidelines.
Before we get there, though, the pre-sentence report prepared by somebody who's in the probation department lays out how old they are, how they grew up, how many siblings they have, their mother and father, what their past history was about, what employments they had, whether or not they've had any issues regarding did they go into any kind of treatment programs, et cetera, what have you. If they're out on bond, you have the right to revoke the bond after there has been a finding of guilt.
Yes, and in some cases, the law requires that the court revoke the bond. Now, I believe that law was passed because and this is when someone's acquitted of a very serious charge where it's almost certain that they're facing a substantial prison sentence. The legislature passed a law that essentially requires them to be remanded.
In addition, when the pre-sentence report, and that's what it's called, it's pre-sentence before the sentence, is delivered to the court, delivered to the defense counsel, delivered to the prosecutor. Yes. They review everything in there, and then we're going to talk about it now. There's a sentencing guideline range for the judge.
Correct.
Under the variables and the scoring, and that's just way, way beyond the scope of what we could decide on this program today. But there is a system of sentencing guidelines here in Michigan, which is always being debated in the state capitol for the legislature, but there is law about sentencing guidelines. A judge will review all of the facts in the case, but also the guidelines, if the scoring is agreed to by defense counsel and prosecutor and judge, then these guidelines could say 12 months to 24 months. And you could go 12 months, you could go 24 months, you could go in between. But can you go higher than the 12 months or the 24 months, and can you go lower than the 12 months?
Well, the pre-sentence report will contain a calculation of the offense variables, remember the offense and the offender, and then what we call the PRV or the prior record variables of the defendant.
Perfect.
So you're gonna apply those two factors. And I think the sentence guidelines, it really is a thorough way of addressing those aggravating factors and those mitigating factors and putting a number on those.
It's a grid. It's a grid.
It's a grid.
And then at the end, the grid determines what those numbers are for jail time, prison time.
Yeah, I mean, perhaps you may see guidelines that are in between that could be probationable. Okay, and I do want to talk a lot about probation because...
Well, I want to go to the prison first because everybody's arguing out there, this should be life, this should be life. Even even though the legislature makes the law, even though the judge enforces the law with the assistance of the prosecutor enforcing laws that they feel
Judge interprets the law.
Yeah, you say interpret, but they're really enforcing it, because without having an order, you speak through your orders to the public. I'm enforcing by saying, if you don't follow this order, you could be held in contempt and ultimately jailed. So when you put somebody on a probation, that means you're not going to sentence them to prison or county time. Okay, anything below 365 days is county time. Anything above 365 days is state time, which is you're going into the state system. Tell us if you don't choose county time or state time and put them on probation.
Yeah. Well, these are the other factors in sentencing a defendant. The first factor is discipline or punishment.
Correct.
Okay? The second factor is potential for rehabilitation.
That's a good part, because that's where you have tools that you can use then.
Right. The third factor is the factor of deterrence. Deterrence. If someone commits a crime and there's no consequence, are you deterring somebody else from committing a crime?
I would say no, because
there has to be accountability.
There's no accountability.
Right. And then the fourth factor is protection of the public.
That is in my eyes, as the role of the prosecutor, a minister of justice, to see that justice is done, whether it be fundamental fairness and also an opportunity for due process, is to ensure the public is safe at all times. And if we don't bring the charges appropriately, then the system looks rigged. But if we bring the charges pursuant to the evidence that's been brought to our attention, and we don't investigate anything, as you know, as a former prosecutor, your investigation tools are limited, because that is the agencies of the law enforcement officials who are charged with that duty. But given the nature of what we can do, we can only bring criminal charges to the evidence that we can prove in a court of law. And it's sometimes difficult, because everybody wants us to charge the highest possible crime. But if I don't have the evidence that I can give that, I have to do, as a minister of justice, fundamental fairness, charge what it is that was brought to me.
Yeah, and that's your purview as the elected prosecutor.
And these policies that you've indicated are policies that I see fit, that says to ensure the protection of society and families in this community, I want to make darn sure that people are watching punishment that needs to be implemented. Not everything needs to have prison, because it's a cost factor too. I look at somebody that may be able to be rehabilitated, that has a mental illness that needs to be on their medication. Is there a cheaper plan by incarcerating a mentally ill? And I don't believe that that's the solution. Somebody needs to monitor and make sure that they're taking their medication. Manic depressive, somebody who's bipolar, you've seen it all.
Well, the reality is that it's probably the majority of our cases, even here in the circuit court, criminal cases, are in some ways related to drugs, alcohol, mental health issues. Those are factors that can sometimes lead a person.
I think you're right.
To those
I think there's a huge majority.
So when we talk about rehabilitation, we'll look at that, and back to the pre-sentence report, that will give a recommendation. If someone does have a drug or alcohol problem, we have a number of ways to provide them treatment. We can test them to make sure that they're not using. So we can protect the public while someone is on probation.
What happens if it's a first-time offender
things.
Versus somebody who says, "Judge, I have a drug problem," and it's their 10th offense? Or where does the line drawn when somebody says, these drugs I want to stay off of them?
Well, we have a drug court here in the circuit court, drug treatment court. We have a mental health court, focused on those individuals that need treatment for mental health issues. We have a veterans court, because a lot of veterans are finding themselves in these circumstances where they end up being charged with a criminal case. And I think those are very important, that we have those specialty courts, as we call them.
And you know what? They don't pay any more for the judges to run those courts. It's during their lunch hour normally.
Yeah.
Which is great.
I did it in the Warren court, and it was really a rewarding experience. I think as personally, and I think a lot of judges would agree with this, you know, it doesn't feel good to send someone away to prison or to jail. What really is gratifying is when you can see someone rehabilitated, go through ordinary probation or even the treatment court and succeed and find a good path in life. It's like it's a hallelujah moment in the court, and there's not many of those. Trust me.
I had like 450 to 500 on my caseload when I was a probation officer, and the success rate I instilled in them. I said, if you want to succeed with me, all you got to do is follow everything that's on here, and I can't violate you.
Yeah.
Please stick to the script. That's what I want you to do. And if you feel you can't stick to it, call me before you break the law, because I don't have any mercy when the judge has already given you probation.
And more on probation. You know, oftentimes the public sees probation, they think it's a slap on the wrist. It's not. Okay, what it is an opportunity for the defendant to prove themselves in the community with the resources. Now, if they violate my probation, I looked up my numbers. I have 230 probationers that I'm supervising. So I'm going to see them. If the agent that's supervising, if they determine that that person violated, perhaps they allegedly committed a new crime, perhaps they didn't show up for the drug testing or didn't take a class that was court ordered, they will be back in front of the court for a probation violation. And then all the rights attach again. They will have the right to a contested hearing, we call it. It's not a trial at a probation violation, but it's a contested hearing where they have an attorney with them and they're able to challenge it and have their full due process rights.
Because they're charged with a probation violation. Therefore, if they are found guilty by way of the evidence that they violated their probation, they could be sentenced to jail now, correct?
Or prison.
Or prison.
Depending on the guidelines.
You got it. And as a result, they're going to have a hearing to determine whether the evidence is there that they actually did the violation. We haven't talked about the victim, and they're the most important. Do you take into consideration the victim and what the victim has to say?
So as far as the victims communicating with the court, that will not occur until sentencing.
And tell us, at sentencing, when you have the pre-sentence report before you, you have the guidelines that are scored, you have all the letters that everybody wanted to send out there to and for the support of the individual that's getting sentenced. What do you look at regarding the victim who comes to court and says, Judge, let me tell you how I feel. I'm the one that was aggrieved by this situation.
You know, Peter, a big part of my job, fundamental part of my job, is to be fair and impartial and not to let prejudice or sympathy affect my decision.
It's tough.
And these cases that we see up here are the heaviest of the heavy cases. The emotion.
There's capital cases here, murder, rape, and armed robbery, all the things that put you in prison the rest of your life. And you have people that are left behind that have to confront the court, never wanted to be in court telling you how much they love their daughter or their son that's life has been taken from them. I don't know how you do it sometimes, but I know how I do it. I have to look at only the victim's eyes and says, what does justice look like through the eyes of the victim?
Well, it's definitely, the court has to decide the sentence. So does the victim's statement impact the court? Of course, that's why we have the victim impact statement provided in the court. That's why we have, Van Rigger-Mortar's
you got it.
Crime Victims Justice.
Yeah.
So this is important too, but I'll do some things a little bit differently. I'll have the defendant, of course the defendant has the opportunity to speak, but if I have a young offender in front of me, and they have their parents here, I'll have their parents come up and speak if they wish, because who knows them better than their own mother or father?
The one that was now convicted has a right to speak in their manner in which to cast judgment at the end. These defendants that come up here and ask for mercy and remorseful about what they did, and to show that they are realizing what it's done to these individuals that they've harmed. you have to weigh that also before you impose the sentence.
I've seen victims break down in tears. I've seen defendants break down in tears. This is it's real life that we're dealing with in the courtroom. And again, all these courtrooms belong to the public. The public has every right to come into the court and
be
watch
right
it.
here watching it.
And I would encourage them, because really this is our democracy. This is the people's democracy. This is our courtroom. You and I, as elected officials, we're just caretakers. I think you called it that, of the office. Your goal is just to make it better than when you got
Leave
it,
the office better than when
Yeah.
you found it, and then you can say,
Yeah.
I did my best. I did my duty, and I did my job.
Yeah.
One more thing, I think it's important, these bonds, because we really never addressed it.
Okay.
Public is outcried sometimes, and I know that starts in the district court with a district court judge or its magistrate, which is acting as a judge setting
Right.
the bonds. People are outcried. They're out.
Yeah.
They feel that this is offensive to them when a big bond isn't set into place.
Yeah.
I know that you have the right, when the case has been bound over, to hear arguments if the bond's too high or if it's too low, and the prosecution
Yeah.
or the defense wants to make a bond argument.
Sure. So when the case is bound over to the circuit court from the district court, that case is already going to have a bond set. It may have been set by the arraigning magistrate or the district court judge.
Yep.
And there's a whole court rule that relates to that. There's really two goals of bond. Number one, we want the defendant to reappear. Okay, we want them to show back up in court. And in most cases, like most misdemeanor cases, the presumption is a personal recognizance bond. A personal recognizance bond is essentially you sign off on that. It's your promise to appear. If you don't appear, you would owe the court whatever that amount is. But you don't have to put any money up front as you would with a surety bond or a cash or surety bond. So there's been a lot of reform in the criminal justice system relating to bond as well, and pretrial release. Now remember, the bond is not there to punish an individual.
Right.
They're innocent unless proven guilty. The factors are, will they reappear? Are they a danger to the public? Now, how do we determine that? Again, this is probably one of the most difficult things to do, because you have to apply all of these factors to an individual. Is this person going to show up again? Is this person going to reoffend?
You don't have a crystal ball, do you?
I don't have a crystal ball. I wish I did.
And you know what? What ends up happening is I invoked a policy and said, on any gun cases in this county, I want a screening and assessment done. What was the reason the person had the weapon? What were they going to do with that weapon? Are they a convicted felon? So it gives the judge an opportunity to see, we have a gun. Not so much that they were going to go ahead. If they lawfully had a gun and it was not stored properly in the car or wherever, that's one thing. But if it's a convicted felon who's out there with a gun, or the police officer find it on the floor mats, I'm more concerned about, if there is a mental health issue, we need to resolve that issue quickly and not go ahead and find out later that we didn't do the right thing.
Well, let me say this too, relating to bond. There are a lot of measures now that we can use to ensure the defendant reappears and the defendant does not present a danger. We have tethers available. We have a GPS tether. We have a house arrest tether. And that's going to measure, with the technology within 1 centimeter of where that person is at every time.
I agree with you.
We have what we call an alcohol tether, which will measure whether or not they're drinking any alcohol. We have random drug testing. We can order the defendant to go to treatment as a condition of bond. No contact orders. These are very important.
No drugs, no alcohol.
When you have a victim, maybe you have a domestic violence case where you have a victim that fears for their own safety if the defendant is released, we can put that no contact provision in there. I can order that a tether be attached, which will notify the victim if that defendant comes within 1/4 mile of them.
Good point. All good
So there's a
points.
lot of measures, because the reality is, Peter, is that we don't have the space in the jails. The jails are very costly. We only want to use the jails only when it's absolutely necessary.
The most severe people. At the end of the day, somebody gets put on probation, somebody gets sentenced. They have a right to appeal, don't they?
Absolutely.
Talk about that process. So it's concluded from your court, and then within, is it 42 days?
It's
By
so
right?
it's if they're convicted at trial, they have what's called an automatic right to appeal. The Court of Appeals has to hear the case.
Has to hear it.
Okay.
And
Now,
an application is filed.
If they plead guilty, and I advise of defendants of this every single day, they have the right to seek an application. So they can file, if they have a good appeal, they have a lawyer, and they have a right to a court-appointed lawyer on appeal as well.
Correct.
So you always have the right to counsel. Even if you cannot afford a counsel, you have the right to court-appointed counsel.
So the case leaves the courtroom, or if you will, your jurisdiction, and then moves to the Court of Appeals
Correct.
to make a decision to see
Yes.
if Judge Sabaugh's decision was fair and just, or whether or not there was any irregularities, let's say, as it relates to the trial, as it relates to any, and even the counsel, if they're ineffective. How many cases get appealed in our criminal justice system?
Oh, I didn't bring that figure. I mean, I would say, it is definitely much more common in the felony court. It's probably everyone that is sentenced to prison is going to file an appeal of some
I'm
sort.
hoping that you said that, because it seems like we have been inundated on the capital cases where they're going to spend the rest of their life behind bars.
Right.
The only way they're going to get out is a pardon, and I've seen that, or some type of reprieve with the parole board that the governor signs, or a appeal where they can bring up issues that would give them a new trial, and then they can negotiate a plea or whatever.
Yeah, you'll hear appellate lawyers say that every trial has mistakes in it, right? It's my job as the judge to minimize those legal mistakes and rule on those as best I can. I may make incorrect rulings. There may be evidence that got in or that was kept out that the jury should have seen or should not have seen. And that may be cause for a new trial. It wouldn't be an acquittal on appeal.
No, I understand. It would be reverse, remand for either a new trial, or if they want a plea, they still have that available if they're offered a plea.
Yeah. And I think, again, I'm happy that we have this process because, again, it's checks and balances. So if this court makes a mistake, you have the Court of Appeals. There's I think 3 on the panel with the Court of Appeals. And you can appeal it all the way to the state Supreme Court. If it's a case, you could appeal it, a criminal case, to the Supreme Court. So
there's a lot
really, the process is so important, and I just hope that the public understands that it's to ensure fairness to the accused, because we all benefit from those rights being protected.
And we would want those same rights if we were accused of a crime in this society that we live in.
It's only fair.
Judge, I want to thank you for the time you spent. I really believe that you have given a really in-depth dissertation, if you will.
Could go on for an hour.
Right, but the criminal justice system is so unique, and some people think it's totally unfair. Some people think it's too lenient. Whatever they think, it's the best system we got. And like you said, it checks and balances a lot of things that are happening. Police work, judges work, prosecutors work, defense counsels work. Thanks for the time that you've given me. I appreciate you.
My pleasure.
Thanks, Judge.